So before we go to March 2023, we are going to finish on question 6 of October 2022. And I read the question. In 1980, Peter Happiness was registered as the absolute proprietor of all parcel land known as Kajiado Block 4, 301, 30, 120. John Hopkins instituted a LADT case number 20 of 2008 at Kajiado Land Dispute Tribunal claiming ownership of the said parcel of land. On 27 November 2009, the decision of the Kajiado Land Dispute Tribunal number 20 of 2008, which was read on 18th March, was adopted. A judgment of court in Kajiado, Magistrate Miscellaneous Civil Application number 45 of 2009, and a decree was issued. In May 2020, John wrote to Peter and a closed transfer form which requested Peter to sign, in default of which he would make an application to have an officer of the court sign on his behalf. Peter did not sign the forms, instead having been granted leave on 15 July 2010. He filed an application in the High Court at Kajiado on 19 July 2020, seeking an order of Centenary to remove this court for purposes of questioning the proceeding of the decision of Kajiado Dispute Tribunal in LDT, case number 20 of 2008, heard on 18 March and adopted as the judgment of the court on 27 November 2009 in Kajiado Chief Magistrate Court, Miscellaneous Civil Application number 45 of 2009. The grounds in support of the application are that the tribunal exceeded its jurisdiction in ordering Peter to transfer the suit property to John, and there was no decision capable of being adopted by court. The application is opposed on the grounds that the ex parte applicant submitted himself to the jurisdiction of the tribunal and never raised an objection that the leave to commence these proceedings were obtained outside the statutory limit, and the claim before the tribunal was that of working and occupying land. You have been instructed by ex parte applicant to act for him. With aid of decided cases and statutory provision, prepare submission on the grounds sought and the legal issues raised that be used to argue the application. So, what are the keywords here, Marianne?
The keywords is the order he's going for, because that tells us that and the fact that it's from a tribunal, so that tells us that he's seeking judicial review for the decision against the tribunal.
Yes. The keywords here is that you are supposed to prepare submissions on both the application that he made to the High Court and the grounds that the expert the grounds that this person called Peter is the person who sought the expert applicant here is Peter. So John, on the grounds that he's opposing the JR, he's having these grounds that that are here. The John was originally the owner of the land is saying that the expert applicant submitted himself to the jurisdiction of the tribunal and never is an objection, commence these proceedings, and all this. So, what do you think about this question?
So okay. I have yet to attempt. Okay, I did not attempt this question. I've yet to attempt any submissions of any sort. But essentially, I think we are laying out our case for why we want the judicial review. So we'll use the grounds that have been given in the questions as some of the issues we'll discuss, which is essentially that the tribunal exceeded its jurisdiction in ordering that Peter transfer the property to John, and there was no decision capable of that decision was not capable of being adopted by court. And then we'll also try and attack the points that that John Hopkins has raised, that we initially did not reject the jurisdiction of the tribunal, and that the leave to commence this period was obtained. That okay, can we argue that one? That was within the statutory period. I'm not sure, and that the claim before the tribunal was that of a working and occupying land. I'm not even sure what that means. So this one kindly guide me.
Okay. First of all, it is good to know how a submission look like. Peter is the expert applicant. He has gone to court saying that the tribunal exceeded his jurisdiction and all those things. Then John, who is the respondent, of course, in the Nini, is attacking the JR application on that that Peter submitted himself to the jurisdiction of the tribunal, and that leave to commence these proceedings was obtained outside the statutory period, and that the claim before the tribunal was working and occupying land. So, first of all, it's very, very important to know how a submission, because you can be told to draft a submission. I've just Google sample submissions on, and it brought this one. I want to share. It's very, very important to know how submissions look like. You put the quote, the heading, then of course the parties. Then you write Submission. In this case, in the question, you say submission for the expert, the applicant. Peter, it's the one who are we asking, dated. You date the day of the exams. Then you start with my lordship. The petitioners make these submissions in support of their application, JR application, on the JR application, which is pending before court. Then you give the brief facts. And we say it for the brief facts in an exam situation, a question of 10 marks, don't put a lot of brief facts. Because it will take you a lot of time, and the brief facts are already in the question. Then you go to the issue. You start by issue. You submit now with, from each and every issue raised in the question. Then the first issue, you can say the tribunal exceeded its jurisdiction in ordering the Peter to transfer the suit property. Then, in this case, you quote the repealed land dispute Land Dispute Tribunals Act, which I'm opening right now. This is a repealed act which was enacted in you can open if you have it. Section 3.1 of the last dispute tribunals state that the jurisdiction of the tribunal is to the division of determination of boundaries and land, including land held in common, the claim to occupy or work land, or trespass to land. That is the jurisdiction of the that was a jurisdiction in a case called Wamboya versus Catholic Diocese of Muranga, Registered Trustees 2003, KRR 399, Honorable Kamoni J. held that tribunals, the Land Dispute Tribunal and the Land Dispute Appeals Committee do not have jurisdiction to have disputes over title to land. Dispute also under contracts of land, we are also not within the jurisdiction of the Land Dispute Tribunal. So they were they exceeded by ordering Peter to transfer the suit. Now, why I found this question to be a bit off, the grounds that John Hopkins, the respondent, grounds that he raised against the suspected applicant seems to have been very valid, making the judicial application made by Peter to be weak. For example, that leave to commence this proceeding were obtained outside statutory period. I told you in civil litigation, you must be very careful through the dates. What is the period by which you must bring the sick leave to appear against a decision of an administrative body? Marianne?
30 days.
No, not 30 days. It is 6 months. 6 months. You see, when a decision of an administrative body is made, for example, disciplinary tribunal, or you have 6 months to bring a JR. This is Order 53, Rule 2 of the Civil Procedure Rule. Leave shall not be granted to apply for an order to remove any judgment, decree, or proceedings for purpose of being questioned unless the application for leave is made not later than 6 months. So if you look at the decision that was made by of course, it was adopted by court. It was adopted in 18th March 2009. So the last day in which they ought to have sought leave to apply for judicial review to quash the proceedings of judiciary of the Land Dispute Tribunal ought to have been 18th March, you had 6 months. That is 18th September 2009. So, and he was granted leave on 15th July 2010. So obviously, he was outside time. Then,
Sorry, what order have you quoted for the 6 months?
Order 53, Rule 2.
Thank you.
On JR, I know you have not done. Then, after you are given leave, you are supposed to file your notice of motions to serve notice of motion, or the substantive application within 21 days. That is Order 53, Rule 3, which I'm reading. When leave has been granted to apply for an order of Madamus provision cetera, the applicant shall be within 21 days by notice of motion. So it is 21 days. If you go to the question again, you find that after he was given leave on 15th July 2010, he filed his application on 19th July 2010. So it was obviously outside 21 days of filing the notice of motion. Of course, the ground that Peter submitted himself to the tribunal is a valid ground. We are not told that he objected to the jurisdiction of the tribunal. And of course, the tribunal was that of working and occupying land. So as I told you, as section 3.1 of the Land Dispute Tribunal, one of the, it hears a claim to occupy or work land. Although I don't know what exactly that means, but it's said here in that section, the same thing. So to me, the grounds in opposition of the ex parte applicant, they were more more valid grounds than those of the respondent. The respondent grounds to oppose the JR application are more valid than those of the ex parte applicant. The student who did this question scored 6 marks. I saw he tried to argue on the bit about the tribunal exceeding his jurisdiction. I want to. Of course, you can see how she's
You're still projecting the Land Dispute Tribunal Act.
Eh?
Or what I was able to see was still the Act, the Land Dispute Tribunals Act.
Now I'm projecting. Of course, he started by giving the facts of the case. Of course, this is not how. Okay, let's first of all share how you should finish your writing your submission before we go to the question. So you argue with your issues as follows. You argue your issues. Of course, the issues are legal issues. You argue. You argue. Then, for future purposes, then you come to how you finish your submission. You finish by saying that this is our humble submission, and we pray for that the ex parte applicant application, JA application be granted. That's how you finish. Then you date the parties. If it is James Ginya advocates for the ex parte applicant, drawn and filed by and to be served upon. Are we together? We are together?
Yes, yes, we are together. We are together.
So then I want to ask to see how this student did his of course, fact of the case. This is not how you do your submission. It's the other way I've shown you. The citation, the parties, then you start by, these are humble submissions. Issue, you discuss issues. he identified the issue whether Kajiado Land Dispute Tribunal had jurisdiction over the case duly registered under whether the tribunal acted in traverse, whether the order of central can be issued in the circumstances, whether the High Court has jurisdiction to grant the orders of the centenary, whether the land tribunal acted by rules of natural justice in the decision analysis on whether Kajiado Land Dispute Tribunal has jurisdiction to make decision on regard to be registered land. It's still true that any registered land that exercise the jurisdiction of land tribunal, the Environmental Land Court established under Article 13 of the environment has the special jurisdiction to handle land within the registered system. The tribunal was therefore ultra vires. Of course, this is not a valid point because the tribunal had powers then because of before it was repealed. The tribunal acted by first realization of the registered land, which is outside the jurisdiction. It further acted to traverse by giving orders occupied landowner Peter Harvey to transfer the register. That was a point, the one I've discussed. The orders of centenary and the nature of judicial review orders as per Section 8 of 9 of the Law Reform Act, which directed that court decision on administrative body which to the exercise covered for fair administrative action as per Act 47. Order 53 of Super Procedure Rules further that such an application can be made through chamber of summons to the High Court. The orders of centenary are meant to be brought forward to cause the decision or administrative body be unfair procedural per the legal principle of us. The orders to cause the decision of Kajiado Register is therefore well sought, and the applicant has met the threshold for orders to be granted because the tribunal acted in jurisdiction. It is strict law. Without jurisdiction, the proceedings should be proceeded, and they cannot tribunal thereof should down the truth, the requirement. Okay, the High Court has jurisdiction to handle the judicial review application. The Article 65, Article 5 conclusion. So I found this question a bit off because the grounds that were, yes, you have a case, but the grounds that the respondent is attacking the question are more strong than the expert application. And you know those statutory limits under judicial review cannot be extended. So if you don't bring a claim within 6 months after the action of an administrative body, you can they cannot be extended. And that's why I was saying, I've been saying in class that if you have been given a question, do constitutional petition, which has no limitations of time. But if the question directly talks about leave things to do, leave stage have already been given. No, now that they want you to do JR. Tribunals questions has not been asked a lot. They only ask kitambo kidogo. My challenge for you on this question is that you go and look at all the tribunals. They're about between 15 and 20. The Legal Appeals Tribunal, NEMA Tribunal, Competition Tribunal, Civil Aviation Tribunal. They are between 15 and 20. Know what they do. If you want to appeal to the High Court the timelines. First of all, the document that institute the appeals to the High Court, then the timelines. Then be able to draft the pleadings that are involved. I suspect a tribunal. Have you dealt with tribunals?
No, I don't think we'll be able to cover it in class.
Very good. That's why now it is very essence. You see what the benefit of attending such a class. I know some of these things you will not be able to do them.
Yes.
So do this, draw a table, draw some matrix. Tribunal, jurisdiction, documents for appealing. Okay, the documents you need to file when you in the tribunal, the timeline of listening to a case, appeals timelines, appeals document, then be able to draft. Because this is a question that have not been tested. And it is highly likely it might come. For JR have been tested a lot to do a JR application. The JR law timelines, all those are in the QA day to draw JR. Sawa sawa.
Yes, Mwalimu.
So we go now to nini, to question. Now we go to March. Question 1. As a student in advocate training program at Kenya School of Law, you do up as an intern at a law firm of Oyali, Biosa and Company Advocates. The law firm is based in Shule ya Sheria Plaza, ground floor along Langata South Road in Nairobi. The law firm email is that Fumoli Yogo, a client has come to the office and you have been assigned to make instruction from him. He gives you the following information. On 9th, 2022, he was going to vote in the general election at Westlands Primary School. Having alighted from Matatu that he had voted from Kambegemi to Westlands, he had to cross Wayakwi to get the polling station at Westlands Primary School. While crossing a duly designated and marked pedestrian crossing point, motor vehicle registration number that is registered in the neighboring Republic of Uganda drove so fast as if from nowhere and knocked him down, causing him multiple injuries. The police abstracted the possession shows that the owner and the driver of the motor vehicle was one Kwandudu Supendwa, a Ugandan national who was visiting Kenya for our conference. Supendwa's statements with the police at the nearby Parklands police station indicated that the time of the incident he was rushing to Kula Shiba Hotel along Mombasa Road for a conference. The address on the said statement is that his email address is also provided as that medical reports from Ponokara Hospital in Parklands area where Fumbo was treated for 4 months so that they suffered a broken arm as well as multiple bruises on the head and the stomach. His sleep in the possession of Fresh show that he have already spent 2.5 million on medical treatment. The doctor projects post-discharge medical review procedure will cost another shillings 500,000. Your research on a case law of similar injuries shows that the expected compensation of pain and suffering and also amenity is in the range of 3 million to 3.5 million by virtue of the recent awards by courts in similar cases. Fumo greatest concerns that the criminal procedure in traffic case that Super is being facing from the incident come to a judgment in 2 weeks. By law, the exhibit motor vehicle that have been in Parklands police station will be released to the accused after 14 days of judgment in the criminal traffic case. Mr. Sweber will Saturday drive the said motor vehicle back to Uganda. Mr. Sweber has no priority interest in Uganda and he ordinarily lives in Uganda. His presence in Kenya on 9th August 2022 was purely on conference attendance in his subsequent presence has been to attend his traffic case. FOMO is therefore concerned that whatever compensation that may be awarded by court against Mr. Sipembwa will not realize in execution unless the motor vehicle UBA remains with the boundaries of Republic of Kenya. You have just briefed the managing partner of the firm of Oyala Boise, who in turn has instructed you to prepare a draft letter of demand together with draft reading and draft of the necessary application that addresses Mr. Fumo's concerns on the execution of the favorable judgment that may arise from this case as expressed above. You have a reputation of generating impeccable drafts as the office. Prepare the draft demand. So, I saw you have sent me two documents. One is question 2. The other one is question?
Question 1, the whole of question 1 together, and then question 2 separate.
Good. Let me open. For you to be able to pass this question, to be able to do drafting, I want to repeat that. First of all, you are supposed to be honest. Don't look anywhere. If someone is looking anywhere and is doing the question, you are just cheating. You are just cheating yourself. Secondly, the timelines. The timelines are very, very important. For example, the combined question for this is 20 marks, which means that this question combined the way it is, you are supposed to use at least 50 marks. So timing is very, very important. Can you know the time you took to do this question?
Honestly, that question 1 nearly took me 2 hours. It was a long time.
Yes. Yes, you see now, that's why I'm telling you if, for example, you do a question within 2 hours, that means you are left with 1 hour to do other 5 questions. First of all, you even if you do question 1 very well and you are not be able to do the others, you not pass this paper. So that's why I usually tell people that you time yourself. After the 50 minutes are over, go to the next question. It's better you have unfinished question than do 1 question only and the others are left, because you need to balance everything. So next time, kindly be able to time yourself. Be timing yourself. I like to be knowing the time that you have taken. Sawa sawa.
Yes, Mwalimu, I'll try. I'll be indicating where I was able to time myself.
Yes, in fact, you can indicate here before the question in the heading here. This question I did between this time and this time. This time and the next question, this time and this, so that we can calculate. Because if your timing is wrong, you will not be able to do these papers well. So the law firm is given. I don't think that is a big nini. Email reference, that's okay. Advance copy the email. Demand letter is not very difficult. Demand for compensation for personal injury by you on. Demand for compensation for personal injury by you on Fumorondi. The English there is not 100%. You can say demand for compensation on personal injury that you caused on Fumo Liongo. You have been instructed by your client Fumo Liongo to address you as follows. On 9th of August 2024, crossing the along Yaqui on a designed pedestrian, crossing our client, we are knocked down by a speeding motor vehicle registration number, which is registered on your name. Our client suffered multiple injuries, namely a broken leg, a broken arm, multiple injuries on stomach as a result of the accident. Consequently, he underwent treatment at Par Hawkins Hospital, which cost him that. The doctor further advised that our client would be required discharge procedure and reviews, which will cost $5. Our client thereby demands the following amounts from you: compensation for pain and suffering, medical expenses. Please take note if your client demands are not met with it, we have instruction to sue you without reference to you. The demand letter is okay. It captures the main things. And demand letter is a question that is usually tested a lot, both in legal writing and drafting, and civil litigation. Then we go to the next. Now during the print itself. In claims for accident, to sue for negligence of accident, use a plaint, the defendant. In the Republic of Kenya, in the Chief Magistrate Court.
I had a question.
Yes.
When do you know when to use a statement of claim vis-a-vis a plaint?
Statement of claim.
Yes.
Statement of claim is usually used in in employment and labor relations. In employment and labor relations cases, you institute a case through a claim. That's why that is when you use a statement of claim. But for plaint is a default. Plaint is a default where the statutes does not say the exact pleading that you should use to institute. Usually used a plaint. Are we together?
Yes, thank you.
Statement of claim is in the employment and labor issues. In employment issues. So, the Republic of Kenya, the Chief Magistrate Court at Nairobi, in the Commercial and Tax Division. How did you come to the conclusion that this is a Commercial and Tax Division matter?
I know it's supposed to be a commercial matter, but then now I know it's called commercial and tax. I wasn't sure I can separate the name and just call it in the commercial division.
No, this is not a commercial and tax matter. Commercial matters, of course, commercial matters are between things to do with companies. What we read in companies, mergers and acquisition, all those things, insolvencies, nini. This is a civil case. Are we together? So it must be in the civil division. In fact, Chief Magistrate Court do not have divisions. Divisions are in the High Court. And now the employment and labor relations and the land courts have divisions that were introduced just the other day. Land appeal and the others. But in Chief Magistrate Court, you don't have divisions. You just go to the civil register. So here you say, the Republic of Kenya in the Chief Magistrate Court. What's the pecuniary jurisdiction of the Chief Magistrate of the Magistrate Court?
The pecuniary I know it's for matters below 20 million for Chief Magistrate.
Sorry?
Is it matters below 20 million? 20 million goes to the High Court, so matters below 20 million are in the Magistrate Courts?
Yes.
Yes.
Yes. And resident magistrate hears matters. The Chief Magistrate is 20 million by below, but the residence also magistrate has a cap. Just in a case that sorry?
It's just that I can't remember, but they differ. There's one for 3 million, one for 5 million, like that.
Very good.
I think 20 and above.
I think for exams purposes, of course, what you are claiming here is more than 5 million. So you put in Chief Magistrate. I think for resident is 5 million, but you go and investigate.
Yes. I have that chart somewhere. It's just that I don't know where I've put it, but I have it. But I thought as long as I'm claiming below 20 million, but I don't put a specific cap because of like general damages. So Chief Magistrate is safe.
Yes. No, not for this question. For your knowledge, you can be asked a question. that ask jurisdiction of each and every magistrate.
Yes, yes.
So you need to know civil suit Fungorioyo plaintiff versus defendant. Plaintiff. The plaintiff is a male adult of sound mind within the public of care. His address for the purposes of services Ogiora and Company ya shule ya sheria ground floor along Langata Road, Nairobi. Email. The defendant is a male adult, domicile and is residing in Jije, Uganda. The address for further service this shall do the plaintiff advocate's office on 9th 2023. The plaintiff was going to vote in the general election at Westlands Wayaki. As he was crossing the designated pedestrian, he was knocked by a speeding motor vehicle registration number. The police had identified the belonging to the defendant who was in Kenya for a conference. In his statement to the police at Parkland Police Station, the defendant indicated that he was rushing to Kuleshiba Hotel around Mombasa. As a result of the accident, the plaintiff suffered multiple injuries, broken arms, broken legs, and multiple bruises, as he said in the stomach. The plaintiff has been undergoing treatment for 4 months at Parkland Hospital and incurred the following cost. The plaintiff has also suffered pain and suffering as a result of the accident. The plaintiff issued the defendant with a demand letter for damages and costs incurred, which the defendants are neglected or refused to meet. There is a related criminal case between the parties about the accident. The cause of action arose within the jurisdiction of this honorable court and the defendants cause of injury, reason whereof the plaintiff prays that the judgment be entered against the defendant. Specific damages of 3 million, compensation of pain and suffering, general damage, cause of the saint. Dated at Nairobi, this day, Ogile advocates draw and filed by to be served upon. There is one very, you have done well, eh?
Yes.
There is, but there's anytime you are anytime you are claiming breach of any case, when you are claiming negligence, you must give particulars of negligence, because this is the negligence of this person who was driving here. Very important, and it's in the civil procedure rules. You must particularize the negligence, which many students usually don't do. And I want to share a document just to show you how you should particularize. Of course, you have done well, but to make it more good and particulars, and this is very important. Sample fatal accident print. This is uploaded in the notes area. Can you see this? Can you see what I'm projecting?
Yes, I can.
Yes. So these are, of course, these are claim, like the one you did, but the person died here. It was fatal accident. So you particularize of negligence of the first defendant. driving the said motor vehicle in excessive speed, driving the said motor vehicle without due care and attention, failing to manage control the said motor vehicle so as to avoid the accident, failing to take heed notice on the board the motor vehicle number, causing the accident, failing to adhere to the highway code and traffic. So, particulars of negligence are very, very, very important in a claim, in a plaint for negligence, for accident. You may also particularize the special damages. You can see here they have particularized the special damages. You know, the special damages are those things that you can quantify. You can also particularize in your question. KRA search, mortuary, coffin, the things that you are given money. But general damages you can't quantify. So of course, this was on a law reform. The person died. General damages, special damages, cost of the suit, any other relief. So it is also very, very important to particularize the special damages. Are we together?
Yes, we're together.
Then, of course, a plate is accompanied by a verifying affidavit. But for purposes of this question, it was not necessary because the plate is very long and I think it is a question of 8 marks. So the plate, doing the plate was enough. But in another question where you are given 15 marks or 20 marks to the plate and verifying affidavit, then now we go to the next question. Draft the necessary application, which we address the draft the necessary application which address the Mr. Fumbo's concern of the execution. Remember, he has a vehicle and it's going to be released. So he may run out of the country. Let me project what your document again. Welcome, Ruth.
Well, thank you.
Now, I'm projecting. I hope you can see. Now, this question is how many marks? The first was 3 marks. The 5 marks, 8, 7. So, when you say you use 2 hours, now I see where you wasted your time. I told you if for exam purposes, you don't repeat. If you have already done the citation of the parties, you don't do this again. You don't do republic and all those things, and the parties, pretty or defendant. You go straight to the pleading, and for purposes of this question, because it's 7 marks, certificate of urgency is also not necessary. You go straight to the notice of motion. So you just write notice of motion. No one will penalize you because of that, because of time. Because already you have known the parties. Take note that this honorable court be moved on this under civil procedure, that rule 39 civil procedure rules. Order 39 is on what, Marianne?
Attachment and arrest.
Yes. You can also quote order 40 on injunction. You can also quote order 51 rule 1. Any notice of motion, you can quote order 51 rule 1, the one that I showed you last time. Take note that this honorable court shall be moved on in the morning and forenoon thereafter, that the council know of the practice can be had on the that the application be certified as urgent, that the motor vehicle do remain within the boundaries of the Republic of Kenya, that this honorable grants an injunction, a Marev injunction, which application is based on the grounds that execution or decree will not be certified unless the motor vehicle remains within the border. The applicant has arguable case with high probability of success, that the defendant is a foreigner, as such there is a high likelihood of the vehicle being taken out of the country, which application is further supported by an ex advantage shown by Fujomiji and another such of the ground to be adduced at hearing. You don't do the dated at Nairobi. This one you can date at the end after you do the supporting. No one will penalize you because of that. Even putting this Biosiri and company advocates, you remove Republic, you go straight to supporting affidavit. If we know an adult of sound mind residing in Kenya, do hyper make an state as follows. You make the affidavit as short as possible, because these are just 7 marks. That the exhibit motor vehicle defendant character will be released in 14 days. That once the defendant delays possession, we remove the property from the borders of the Republic of Kenya. That in the interest of the justice for the plaintiff and the honorable should grant the Mareva injunction requiring the motor vehicle remain within the country. That the plaintiff has an arguable case within his success. That what deponent is true and correct to the best of my knowledge. Then, of course, you put a commissioner of oath. Your document, you did not scan well. Pali ya commissioner ionekani vizuri. Very, very important. So when there's this day, then you date. You can put drawn and filed by. So the parties drawn and filed by, the citation or the heading of the pleadings, those one you don't, in an exam scenario, you don't need to continue repeating them, so that you save time. Otherwise, if you continue repeating them for any pleading, you are going to waste time, and it is not helpful. The marker is just going to mark the heading on the first pleading. You not award you another marks. For example, if you put in the Republic or under supporting affidavit, they just want to know you know how to draw a notice of motion, the order that you have been brought, the prayers that you are praying, the grounds. Just that. And of course, when you are finishing the supporting affidavit, you say they are shown by the said. Very, very important for the affidavits. This question on plaint have been asked where accident is involved. Have been asked several times in the past, so it was not a new question. We can look at the highest if you look at year 2008 to 2019, part B, which you have, there are various ways in which a plaint can be brought, and these are questions that can come. I told you that the plaint is a default pleading. For example, a breach of agreement between a tenant and a landlord is brought at the plaint. Ruth, did you draft?
No, but I'll send to you tomorrow. I had a long day today. I'll send you tomorrow.
You see, it has been plaint institute default pleading when law governing a given cause of action does not state. There are so many plaints there that you are supposed to do. For example, dispute between landlord and tenant, fatal accident plaint. It has been tested many times. I think this was since 2005. This was the fifth time. Defamation plaint, claim for breach of contract. Generally thoughts, you bring them at the plaint. Breach of contract, malicious prosecution, loan recovery, infringement of a copyright, negligent, a plaint to compel defendant to pay the plaintiff dividends. These are some of the questions that have been tested using plaint. You can look at them and try to draft. And of course, we are going to, during our year 2008 to 2019 drafting, we are going to do some of this drafting. But before that, you can be practicing on your own. So this was not a very difficult question. For someone who have practiced drafting, who know the civil procedure rules, and who has also looked at the past questions, past papers. Of course, this was not a question, a difficult question. So I want us to go to the next question, which is will be our final question for the day. And I'm going to read. David Mogara filed a suit against Joe Doe, claiming adverse possession over that parcel of land known as Gong Block 14755. In March 2019, he obtained a judgment and the court ordered Joe Doe to transfer the parcel of land to him. David never followed up the matter to have the land transferred to him. Joe Doe passed away in June 2020. Peter Joe, John Ed's son, who was away for studies in the United States of America, returned home and found David Moran the parcel of land. He obtained letters of administration and filed a suit against David, seeking to have him evicted from the suit land. David has raised a preliminary objection on the property of the suit filed by Peter on the grounds that is an abuse of the court process. The matter has been placed before you and the parties have made rightful submission on the preliminary objection. With aid of decided cases, write a ruling on the preliminary objection. What do you think about this case, Ruth?
Okay, first of all, whenever I see preliminary objection, I think it is the Mukisa case. The Mukisa Biscuit versus West End Distributors. That is one thing that is coming to my mind. And then you'll have to look at what are the PO about. Is it a statute limitation or what? Because I'm looking for the ruling.
Sorry?
Because I'm writing the ruling. Those are something I would look at. And then I would look at calculate how long has it lived so that the adverse possession can come in place. Is it more than 12 years? And then 10 marks. Then I'll also have to quote what is it called? Order what? That you what?
Sorry?
No, I'm trying to remember which order you give for adverse possession.
37.
Yes, 37. Order 37. Anything else?
You know, you have tried, but you see, I gave you instructions on Saturday morning. You had Saturday, Sunday, Monday. Today is Tuesday. It is one thing to say what you are saying right now here, and it's another when you draft and you project. Because you see, in a drafting, you must condense your thoughts in a writing, and I want you to see how you have drafted, and that's why I usually say drafting is a skill. I want you to see the reasoning and even your conclusion. Very, very important, because you may reason well. Mukisa Biscuit, preliminary objection versus West End, but what is your conclusion? Are you going to allow the preliminary objection or you are going to disallow? What are the orders you are going to give? Are we together?
Oh, yes, we're together.
So kindly, when I tell you to draft, this drafting are for your helping. They will help you a lot. you remember when you come to write your exam, you remember all the things that I have said here, because you did it practically, like what Marianne have done. So of course, let's see what Marianne did and see how he wrote the ruling. Now, you are.
Mwalimu, I had a question
Yes.
going to this ruling.
Yes.
Hi. When an application is made and
Yes.
you've been tasked with making the ruling, I have an issue with how we frame parties. Because in this question, John Doe had instituted a suit now against David when he, as the representative of John Doe's estate again to get rid of him.
Yes.
So I didn't know now the ruling was just going to be part, because that's how I answered it. But I was confused because I have seen before where you might have a ruling in between and the parties look a bit different. So is how I framed the parties correct?
Yes, how you are framed is correct. Because this is an ongoing suit. Peter Doe, suing as the representative of estate of Joe Doe, is the one who has sued this person who got adverse possession. And you are ruling on the preliminary objections. So you are the judge. You say that this preliminary objection brought by blah, blah, blah. The David Mungara, the respondent in this case, and the preliminary objection is this. Then those are brief facts. Then you go to the issue. Then you go to the analysis. Then you go to your orders you have given or the disposition. So, of course, we are in the question. I want to look at the question. Peter, you obtained a task for a suit against evicted. So, a suit on eviction, a suit to evict someone, of course, was filed in the Environmental and Land Court. Gong. So, you go to the Environment Court and Land, which is near Gong. Which one is that? Nairobi. Civil suit. So the heading is good. The parties is good. So this one we may be given 1 mark, and the parties citation is good, ruling good. You go to the procedural background of this matter is that the respondent David sued the late Joe adverse possession on the parcel of land. In March 2019, the respondent obtained a favorable judgment that ordered Joe Doe to transfer the land. To the transfer that to him. However, the respondent did not follow up the matter, and Joe Doe died in June 2020, having not transferred the land. The applicant, on returning from the United States, found the respondent on the parcel of land, and after obtaining letters of vision, filed the present suit against the respondent to evict him from the suit. The respondent does a notorious objection objected to the priority of the case on basis that it was an abuse of court process. Having considered the parties' submission, the main issue for determination when you are doing your ruling, put subheadings. For example, brief background here. Sawa.
Yes, Mwalimu.
Then you put issue. That's the issue. Then number 2, issue. Then the person who is marking so that you are now at the issue. Then you put what is the issue? The issue is whether the preliminary objection is valid. That is the issue. And it's not the applicant. Whether the respondent has met the requirement for raising a preliminary objection. Remember, it's David this person who had advanced possession is not the applicant. Are we together?
Mwalimu, but in this case, it's David who's raised the preliminary objection.
Yes. It's whether the applicant.
Oh, the respondent.
Yes, the applicant. Are you gotten my point?
Yes, I've understood.
Yes. So then now you come to subheading number 3, analysis. The case of Mukisa Biscuit versus Ed define a preliminary objection as a question of law when its raised is capable of disposing of the suit as a whole. The court further allowed the condition for preliminary objection to succeed as first, it must be first the question is on a point of law, not on controversy of facts. Second, it's argued that on the assumption that all other facts pleaded on the other side are correct. Finally, objection cannot be raised if any facts has to be ascertained or if what is sought is in the exercise of judicial discretion. In this matter, there was a judgment entered in March 20 against Jodo, a fact which the applicant does not dispute. Under section 17 or 7 of the Civil Procedure, the doctrine of the judicata bar parties from instituting a suit. A further suit in respect to any particular cause of action already concluded by the court of competent jurisdiction. The applicant suing the personal representative of the late Jordan as instituted. The applicant suing as the personal representative of the Jordan has instituted the same suit over the same subject matter. I therefore agree with the respondent that the matter here already determined and disputing with abusing the court process. This is my finding that the respondent has met. Now you put the disposition of order that the respondent has met the condition of a preliminary objection, which is allowed. Then the cause of the case is dismissed and the applicant shall have the case dismissed. You put A, B, C, D, disposition of order, preliminary objection allowed. Then case dismissed. Then C, applicant to have cause of the suit. Dated at Nairobi this day of March 2023. This is one way you can answer this way. Of course, the highest scoring student argued this way because it was adverse possession, and being given a judgment of adverse possession, the matter has already been litigated, so he could not leave. The judgment was given and is not could not be executed. But also there is a way you can argue and say judgment when the judgment was delivered and the lad he was given the order for adverse possession, but this is not transfer. The judgment is valid for 12 years. Section 4 of the Limitation of Action Act. So he had 12 years to execute the judgment. So there is no way until the 12 years have ended, there is no way Jodo could tell him to vacate. Are you getting that argument?
Yes, Mwalimu.
Yes, then one of the orders also here you can say that the court will say that David Mugara can be ordered to execute the judgment in the adverse possession in that case, to go and draw a decree for execution. That is also one, and the Jodo, Peter Do to sign. Remember, under section 1 ABC and the inherent jurisdiction of the court can give any kind of orders for just determination of the case. So that is one of the orders you can also include. But the way you have done this is okay. So in an exam, you'll be told to do judgment and rulings, both in criminal and civil. The most important thing for you is to know the law, because the examiner is testing you on your analysis of the law. Judgment of or a ruling. That is a very common question. They are testing you on understanding of the law and your analysis and the orders. You can even analyze well, and you can even know the issue of the law, and you know the law, but your analysis, application of the law be wrong, then your orders that you give are wrong. So it is very, very important. And this you can only know by studying hard, what we are now doing. So on Thursday, we are going to do question 3, 4, 5, and 6. There's a drafting of legal opinion, question 5 draft. Be prepared. Said the adverse is possible, like the way Nani did. Marian. In fact, there are 2 legal opinion, question 5 and 6. So do them, be prepared. And if we finish on Saturday, we are going to start on civil procedure drafting.